Today, a New York appeals court rejected Donald Trump's latest attempt to delay his civil fraud trial, allowing it to continue full steam ahead next week. And now that we have wrapped week one of this trial, we have some riveting new details, courtesy of Trump Organization Comptroller Jeff McConney, who took the stand and admitted that the valuations of Trump's properties were fraudulent, not by accident, but by design. Now, we have known for a while now that Trump was allegedly inflating the value of his apartments and his golf courses and so forth. Attorney General Letitia James presented that evidence to the judge in this trial, who has already found the Trump Organization guilty of fraud. But today we were given a detailed look at the extent to which Trump's business hyped the value of his properties, and it is staggering deceit.
I want to annotate what you just heard before we go deeper, because several things in that segment deserve precise treatment. First, the appeals court rejection. On the same day McConney took the stand, October 2023, a New York appellate panel rejected Trump's latest attempt to delay the proceedings. This was not the first delay attempt. It was, at that point in the trial timeline, part of a documented pattern of pre-trial legal challenges that I will address in detail in a later section. The relevant point here is that the court system at the appellate level looked at Trump's delay arguments and declined them. The trial proceeded. Second, the specific phrase, not by accident, but by design. That framing matters analytically. The distinction between accidental misstatement and deliberate design is the distinction between an accounting error and fraud. Errors happen. Methodological choices are made. When a person responsible for producing financial documents testifies that the choices were deliberate, that the numbers were constructed using specific methodologies that the person who built them now acknowledges were indefensible, the accident defense collapses. McConney's own testimony removed it. Third, Judge Engoron's line, "I think any high school student knows the right way." I want to spend a moment on this because it is not merely a memorable courtroom quip. It is a documented judicial statement made from the bench in response to McConney's explanation of his methodology. What Engoron was documenting in real time in open court is that the defense's explanation for how the valuations were built failed to meet even the most basic standard of credibility. When a judge says that a high school student could identify the correct methodology, the judge is making a formal finding, entered into the record, that the methodology actually used was not a good faith alternative approach, but a departure from basic professional standards. That finding is in the permanent record. It does not expire. It was upheld at every appellate level that reviewed it. Now let me take you through the specific properties, because the pattern only becomes visible when you look at all of them together.
Last week, Judge Engoron ruled that Trump had inflated the value of his beach club by a whopping 2,300%. According to Trump's financial documents, Mar-a-Lago was worth between $426 million and $612 million, all based on the premise that it could be sold as a private residence. Now, today we learned that that was a complete farce, and that is because the deed for Mar-a-Lago clearly states it can only be used as a social club. And if Trump can't sell Mar-a-Lago as a private residence, then it would likely be worth a whole lot less, to the tune of $18 to $27.6 million, according to Palm Beach County's appraisal. And then there is Trump's iconic Rococo apartment in.
What you just watched is a document. I want to be precise about that because it is easy to watch that clip and process it purely as political theater. The defendant performing contempt for the court in front of cameras, while his lawyers visibly struggle to contain the situation. That reading is not wrong, but it misses the analytical significance of what was actually happening in that courtroom from an evidentiary standpoint. When a defendant testifies, they are creating a permanent evidentiary record. Every statement made from the witness stand is documented, transcribed, and entered into the trial record. It is available to the judge when writing the ruling. It is available to appellate courts when reviewing the judgment. It does not disappear. Trump's documented statement from the stand, "How do you rule against somebody and call them a fraud as the President of the United States who did a great job?" is not just a revealing piece of political psychology. It is a documented statement by the defendant under oath asserting that his title should have protected him from a civil liability finding. That is not a legal argument. No provision of American law provides that holders of the presidency are immune from civil fraud liability in state court for conduct predating or unrelated to their official duties. The statement is legally incoherent as a defense. What it is, as Engoron's ruling subsequently documented, is evidence bearing on the question of contrition and remorse. Courts consider a defendant's response to findings of liability when assessing appropriate remedies. A defendant who appears before the court, screams at the attorney general, attacks the judge's impartiality, and argues that his title should have prevented the finding, is providing the court with a documented record of their relationship to accountability. Engoron used that record. His ruling's language, the defendant's complete lack of contrition and remorse borders on pathological, is a direct documented response to what Trump produced from the witness stand. The defendant gave the judge exactly what he needed to write that sentence. Now, let me turn to the Deutsche Bank relationship because it answers the question that all of this documentation ultimately exists to answer. Did any of this actually matter? Was there a documented victim? The Deutsche Bank relationship, documenting the benefit. The question of whether fraud produced a material benefit is central to any civil fraud case. It is not sufficient to establish that false statements were made. You must also establish that those false statements produced a concrete advantage for the party who made them. In this case, the documented advantage is specific, calculable, and entered into the permanent record. Deutsche Bank was Trump's primary lender for over a decade, a period during which most major American banks had stopped extending credit to him following his 1990s bankruptcies and subsequent defaults. The loans Deutsche Bank extended were secured in part by Trump's personal statements of financial condition, the same documents that McConney built using the methodologies described in his testimony. Based on those statements, Deutsche Bank set interest rates. Higher stated asset values signal stronger financial health. Stronger financial health produces more favorable lending terms. More favorable lending terms mean lower interest rates. Lower interest rates, compounded across large loan balances over years, produce a calculable financial benefit. Engoron calculated that benefit from the documented record of Deutsche Bank's own loan files. The figure for Deutsche Bank loans alone, $168,491,697. $168 million in interest savings, documented from the bank's own records, attributed to the differential between the rates Trump actually received based on his inflated financial statements and the rates he would have received if accurate numbers had been submitted. A second transaction involving the old post office building in Washington, converted to a Trump hotel using a government lease, and Deutsche Bank financing, both obtained with the inflated statements, added $126,828,600. Two transactions, two documented lines of credit, combined benefit approximately $295 million out of the total $354.8 million disgorgement finding. And here is the specific evidentiary detail that eliminates the victimless fraud defense. There is a letter in the trial record, McConney to Deutsche Bank transmitting Trump's financial statements. The letter states that the documents are being provided as required under the conditions of the loan, not voluntarily. Not as supplementary information, required. The bank specifically demanded these statements as a condition of the lending relationship. McConney sent them. The bank received them. The bank used them to set rates. The disclaimer on the statements, the clause stating that the numbers should not be relied upon, did not override the loan agreement's explicit requirement that the documents be submitted. The loan agreement said, send us these numbers. The disclaimer said, don't rely on them. McConney sent the numbers. Deutsche Bank set rates based on them. Engoron calculated the documented benefit to the cent. McConney's consequences. The accountability gap. I want to address McConney's personal consequences with the same precision I applied to the property valuations, because the contrast between what he admitted and what he faced is analytically significant. McConney testified under immunity granted in connection with the criminal tax fraud case that preceded the civil fraud trial. The immunity protected him from prosecution for the conduct he described. He left the Trump Organization in early 2023, before the civil trial began, with a $500,000 severance payment. Engoron found McConney liable in the civil fraud case. His testimony, intended to explain the methodologies, became part of the evidentiary record establishing the fraud. The judge noted that McConney's credibility was compromised. He initially denied under questioning that Weisselberg had asked him to help commit tax fraud, then acknowledged it under further examination. He also testified, and this is a significant evidentiary admission, that at some point he gave up trying to push back against valuations he believed were wrong. He acknowledged that he knew some of the numbers were not accurate and continued producing the documents anyway. This is not a description of an employee who was unaware of the problem. It is a description of an employee who identified the problem, attempted some resistance, and eventually continued participating. McConney's documented consequence: found liable in a civil proceeding. $500,000 severance on departure, no prison time. The immunity from the criminal tax case remained in place. Compare that to Alan Weisselberg, the Trump Organization's CFO, who served 100 days at Rikers Island on the criminal tax fraud conviction, and a second stint of 100 days for perjury during the civil fraud trial. Compare it to the documented outcome for Trump himself: the civil fraud judgment, the 3-year New York business bar, the hollow and untrue finding on sworn testimony, and the presidency. The person who built the documents, found liable, $500,000 severance, no prison. The person who directed and oversaw the operation, 2 stints at Rikers. The person who signed the documents, whose name was on the statements, whose properties were valued, who told the judge his title should have protected him, the White House. That is not an editorialized conclusion. That is the documented outcome of this proceeding, stated as precisely as the record allows. The pretrial delay pattern: 3 attempts, 3 losses. Before McConney ever took the stand, Trump's legal team mounted a documented series of challenges designed to prevent the trial from proceeding. Understanding that pattern matters because it reveals the strategic logic of the approach and the consistency with which courts rejected it. September 14, 2023. Trump argues that an earlier appellate ruling required dismissal of substantial portions of the case. Justice David Friedman temporarily stays the trial pending review. September 28, 2023, 4 days before the scheduled trial start, a 5-judge appellate panel reverses the stay. 2 pages, unanimous. The trial begins Monday, same day as the stay reversal. Trump files a personal lawsuit against Engoron, arguing the judge violated Trump's constitutional rights. The same 5-judge panel that just reversed the stay reviews the lawsuit. Same result: denied. After the gag order is imposed, Trump files what is called an Article 78 petition, a separate legal mechanism attempting to challenge the gag order and generate a parallel legal track that might disrupt proceedings. Also denied. 3 mechanisms, 3 separate legal vehicles, 3 documented losses, all before a single witness took the stand. Here is the analytical observation the original source makes correctly, and that I want to reinforce. Each filing generated news coverage. Each temporary stay produced a headline that was readable, in isolation, as "Trump wins a round." The legal record, looked at in aggregate, was an unbroken sequence of defeats. But covered as discrete events, the picture appeared murkier than the documented record warranted. This is a documented strategic pattern in how Trump's legal team approaches proceedings. Generate procedural activity that produces temporary headlines suggesting forward momentum, while the underlying legal record consistently shows those activities failing. The gap between the narrative running in media coverage and the actual documented legal record is part of the architecture of this approach. By the time McConney testified, Trump had spent months framing the trial as a witch hunt. The legal record at every step said otherwise. Both tracks were running simultaneously, and they produce different pictures depending on which one you are looking at. The final accounting: what remained after appeal. I want to close this analytical section by being precise about what the appellate process did and did not do to the Engoron judgment, because the distinction is analytically important. The appellate court reduced the financial penalties. The $464 million penalty figure that appeared in early reporting was brought down through the appeals process. The business prohibition was reduced and modified in certain respects. What the appellate courts did not touch: the fraud finding itself. The documented judicial determination that the Trump Organization's financial statements were fraudulent, built on methodologies that McConney himself described as indefensible, adjusted in a single direction across multiple properties over multiple years, was upheld at every appellate level that reviewed it. The money changed, the fraud finding did not. That distinction is the load-bearing element of the documented record. Financial penalties can be modified on appeal based on legal calculations about appropriate disgorgement amounts. The underlying factual finding, that the conduct constituted fraud, that the methodology was indefensible, that the defendant's sworn testimony was hollow and untrue, that the lack of contrition bordered on pathological, is a different category of determination. It is a factual finding, supported by documentary evidence, confirmed by the testimony of the organization's own controller. Appellate courts apply a deferential standard to factual findings of trial courts that have reviewed the complete evidence record. The fraud finding was upheld. The documents are in the record. The pattern is confirmed. The appellate courts looked at the same evidence McConney described from the witness stand and concluded the trial court's factual findings were supported. That is the documented state of this case. The money walked. The findings stayed. Let me bring this to a close by returning to where we started. Insider testimony. Jeffrey McConney is the most significant witness in this case, not because of what he was alleged to have done, but because of who he was and what he chose to describe. He was inside the operation for 35 years. He was the person whose job was to make sure the numbers were accurate. He left with $500,000. And then he sat in the witness chair and explained, in his own words, in accounting-level technical detail, using the specific language of financial statement preparation, exactly how the documents were built. He described Mar-a-Lago being valued as a private residence despite the 2002 deed restriction that made that assumption legally impossible. He described rent-stabilized apartments being valued as market-rate units despite his knowledge that they were not. He described the celebrity premium added to the Trump Tower penthouse valuation, a number with no basis in any standard appraisal methodology. He described replacing a bank appraisal with a figure $227 million higher at 40 Wall Street. He described including the value of 7 unbuilt homes at 7 Springs, on direction from Eric Trump. He described brand premiums added to golf club valuations using a concept no formal appraisal framework recognizes: every adjustment, same direction, every time, for over a decade. And then he described those documents being transmitted, in a letter bearing his own name, as required by the loan agreement, to Deutsche Bank, where they were used to set interest rates, where the documented benefit, calculated to the cent from the bank's own records, reached $168 million from that single lender alone. The pattern McConney described is in the permanent judicial record. It was upheld on appeal. It is confirmed as fraud at every level of the court system that reviewed it. What it tells us is not primarily about Donald Trump's legal exposure. I have covered that in detail across previous episodes in this series. What it tells us, at a more fundamental level, is about the architecture of documented financial fraud, how it is built, what choices produce it, what insider knowledge looks like when it is finally stated under oath, and what the gap between a public narrative and a documented legal record looks like when you examine both with the same level of precision. The man who prepared the documents received $500,000 and no prison time. The man who oversaw the operation served time at Rikers Island twice. The man whose name was on the statements, whose title he argued should have protected him from accountability, received the White House. That is the documented outcome. All of it is in the record. None of it is editorial. All of it deserves your attention precisely because it is not dramatic speculation. It is what actually happened, verified at every appellate level, stated in the words of the people who were there. This is Matthew John Turner. The question the documented record leaves you with is not a political one. It is an institutional one. When the person who built the fraud receives $500,000 and the person who signed it receives the presidency, what does that tell you about the relationship between the documented legal record and actual accountability? I am not going to answer that question for you. The record is there. The numbers are documented. The appellate findings are public. Read the Engeron judgment. Pull the trial transcript. Check the Deutsche Bank loan documents in the trial record. Look at McConney's testimony in his own words. Then draw your own conclusions. I will see you in the next one.